Hey, I'm firearms attorney Gilbert Ambler, and today we're going to talk about the upcoming Supreme Court case, the Rahimi case, and a way that the Rahimi case that everyone seems to be missing could actually help us undo assault weapons bans, assault weapons, and the NFA. And of course, I know what you're thinking. The Rahimi case, it's about domestic violence restraining orders. How's it going to affect the NFA? How's it going to affect assault weapons bans? I'll tell you in just a couple of moments. But as always, before we dive into this subject, if you have not yet hit that subscribe button, go ahead, hit subscribe, like, comment with your thoughts, and share with your friends. That way you and your friends can keep getting this important Second Amendment related content. Quick refresher on Rahimi. This is an appeal from the Fifth Circuit where the Fifth Circuit struck down a ban on domestic violence restraining orders and the constitutionality of a firearms ban for those subject to a domestic violence restraining order. Now, when the Supreme Court decided to accept this case for the fall 2023 term, there were a lot of people that were very, very nervous in the gun rights community. And they were nervous because the Brune case from 2022 was such a positive case for gun rights. It's done a lot of positive things, but its effect is still making its way through the court. We are still figuring out exactly what it means. And here, the Supreme Court has already accepted another gun rights case and another gun rights case with really poor facts because Mr. Rahimi, by all counts, was not a good dude. Multiple instances of violence, lots of things that are very concerning with him. And so the issue of whether he should have been prohibited from possessing firearms by this domestic violence restraining order is something where gun rights folks are a little bit concerned that maybe the Supreme Court is going to walk back in one way or another what they did with the Brune case. But I'll tell you, I think people are focusing on missing a major point with the Rahimi case that actually has the potential to undo both the NFA and assault weapons bans across this country, and that is the common use test. Now, credit to one of my colleagues, Oliver Krabchek, for pointing this out because he was the one who raised this idea, and I think it's brilliant, I think it's very important, and I hope the Supreme Court takes notice. Mr. Rahimi was in possession of two firearms. He was in possession of a handgun. We know handguns are protected by the Second Amendment because of the Heller case. And he was in possession of a Century Arms 308 sporting rifle, which is a rifle that would fit the definition of an assault weapon in many states, including California, New York, New Jersey. The reason this is so interesting is because when litigating this case, the government never challenged that this rifle was protected by the Second Amendment. This is an argument that the government has in fact been making in other cases. For example, in the pistol brace challenges, the government has been arguing that short-barreled rifles should never get Brune's text, history, and tradition test because they are not in common use for a lawful purpose. They are dangerous and unusual weapons, according to the ATF. Short-barreled rifles are. So the question here is, at what stage does someone get the text, history, and tradition test? When complaining about the constitutionality of a law, does the plaintiff have to first prove affirmatively that the weapons are in common use for a lawful purpose? Or does the plaintiff have to merely show that they are bearable arms? Remember, this was the language from Heller, bearable arms. And once the plaintiff shows that we're talking about bearable arms, which is conduct burdened by the Second Amendment or impacted by the Second Amendment, do we then move on to the history and tradition portion of the test where the burden flips to the government? Because if the government gets their way in these other cases, in some of the assault weapons bans cases that they're litigating, in the NFA pistol brace related cases that they're litigating, if the government gets their way there, the burden will fall on the challengers. We won't even get to a Second Amendment text, history, and tradition test unless we can first show that the weapons we're talking about are not, quote, dangerous and unusual. And of course, this is at times, although some people say, oh, it should be easy, it should be a statistical analysis, often far more complicated than that. We know dangerous is not enough. They have to be both dangerous and unusual. How do we slice this pie? Are we talking about categories of arms, for example, rifles versus short-barreled rifles versus handguns, or are we talking about specific arms, for example, .308s versus .556, because the government's going to try to split it up as much as possible and then argue with hyper-specificity that whatever particular weapon we're talking about isn't common enough to be in common use for a lawful purpose. The inverse, where as long as it's a bearable arm, the burden flips to the government, would be tremendous for us. Because what that would mean is it would take away the argument in all of these assault weapons cases and all of these NFA challenges that say the burden is on us to even get a Second Amendment test. It would flip it to the government. The government is going to have to show that a ban on short-barreled rifles, for example, can be supported by historical tradition back to the time of founding. And I think it's very unlikely that they would be able to do that. In the Rahimi case, because he possessed what would have been defined as an assault weapon in many states, and the litigants, the United States government in this case, did not challenge that it was in common use, essentially that is waiver. And so all the Supreme Court has to say is they didn't challenge it, so it's true. A semi-automatic rifle with a pistol grip and a detachable magazine and a threaded muzzle and all of these features that would cause it to be a problem in some states, the Supreme Court can simply say, we find that it's in common use because the government didn't even challenge us on this. Essentially, it would be the exact reverse of what happened in the Miller case, where this is going all the way back to 1934, where in the Miller case, 1939, the first challenge to the NFA, where Miller, on appeal to the United States Supreme Court, his defense attorney never showed up, never made an argument that the shotgun was in common use, that it was useful for militia purposes. So we never had that argument. Boom, short-barreled shotguns got ridden out of the Second Amendment, removed from their protection. This could flip that back and say, first, the government has the burden to show through historical tradition all the way back to the time of founding, as soon as the plaintiffs show that it is a bearable arm. So huge component, hopefully something that the Supreme Court addresses, can have a tremendous impact in many cases going forwards. And even if there's some bad stuff that comes out of Rahimi, this could still be a very good thing to come from Rahimi. If you enjoyed this content, hit that like button, subscribe, tell your friends about us. Until next time.